Good day, viewers and members at home. Welcome to Labor Talks. My name is Thumele Mmako. Today we are talking about collective bargaining. And on the show we have our legal expert, attorney Modidima Mannya. Dade Mannya, welcome to Labor Talks.
Good day, and good day to the members at home and in the schools.
Collective bargaining has been a serious issue for the past 2 years. Members or workers in general, especially in the public service sector, they've been crying about the failure of government to honor the collective bargaining. How do unions get their bargaining rights?
Look, the bargaining rights arise out of what we call a recognition agreement. If you look at the PSCBC, for instance, you will see that there are parties to that, which is the government, and the unions, which represents the various thresholds of government employees, for instance. So it is a process of recognition that gives you the bargaining rights, the recognition agreement, bargaining rights.
During the collective bargaining process, is it possible for wage rates and other working conditions to be changed?
Yes, remember, the very essence of collective bargaining is an improvement in the conditions of service. What collective bargaining cannot do is to reduce below the minimum what the law provides. If the law says you are entitled to 3 days of family responsibility leave, you cannot say by collective agreement we are reducing it to 1 day.
Can there be a strike or a lockout during the collective agreement?
Look, if you reach a collective agreement, if you sign a collective agreement, you can't strike. You must now enforce the collective agreement. The strike is when you reach a deadlock, so you can't reach agreement. So the strike is meant to leverage you. It's the muscle that you have to frustrate the employer, to get the employer to come back to, talk or to capitulate, as a matter of fact. As I say, for instance, if workers go on strike, let's take an example of a tire manufacturing company, and this company has got a target or has got an order to supply 200,000 tires, okay? And the workers say, well, look, we've disagreed in the bargaining, we have a certificate, we have given you notice, we go on strike. It means that this company can't deliver this order of 200,000 tires. Now, the company has to make a value judgment. We're going to lose this business, or we're going to have to get our employees to meet them halfway so that we can have this order delivered, because that can have medium to long-term implications for the company.
So may we please move to PSCBC?
Yes.
What are its roles?
Okay, firstly, what is the PSCBC?
Yes.
The PSCBC is the Public Service Statutory Bargaining Council. In terms of the Labour Relations Act, a provision is made for bargaining councils. Now, you have got in various sectors. In mining, you have a bargaining council. In the public sector, you have got a bargaining council. In the public service, in the local government, you have got a bargaining council. So these are statutory bodies which manage relationships between employers and employers' organizations on the one hand, and employees organizations on the other hand. So that is the whole purpose. Now, it provides a host of services. And maybe let me indicate that, there's a body called the Commission for Conciliation, Mediation and Arbitration, the CCMA. Now, the CCMA is established in terms of the Labour Relations Act to perform dispute resolution functions between employer organizations and employees and employers. And now the Public Service Coordinating Bargaining Council is that type of statutory body that renders that service for this particular sector, which is the public service. But of course, under it, you have got another structure called the Education Labor Relations Council, which is focused on the education sector within the public service.
How are the unions represented at the PSCBC?
They are actually just not represented, they are party. If you look at the founding documents of the PSCBC, the trade unions and their employer are represented, and that is how all statutory bargaining councils come about. They are parties. If you go to the Metal Industries Bargaining Council, for instance, there are employers' organizations and organized labor who are party to an agreement to establish that. But once it's established, it takes the form of a statutory body.
Is it compulsory for a union or an employer to register with the bargaining council?
It's not about registration. As I say, what happens is that you have got trade unions, say in the public service, for instance, that represents employees of the state. Now, they come as a group. The employer basically is one, but comes as a group because it's different sectors and different departments. Now, these people then agree that we need to have a body that is going to coordinate us. And that is how these bargaining councils are established. So it's not like you have to go and register. For instance, if a new public service union emerges today, say in the education sector, that union will then apply for recognition. And in terms of the constitution and the rules of the bargaining council, if it qualifies, it will be admitted as a member of the bargaining council. Now remember, the unions are not same size. So even the representation is determined by the size of the unions. Of course, the smallest of the unions have got the least representatives. The biggest, of course, have got in terms of the formula that has been agreed to.
Does it have more powers, the bargaining council?
More powers over who? Firstly, as I say, the bargaining council is a coordinator, it's a facilitator, it's a mediator, but it's also an arbiter. So this is now, the structure is formed by the parties. And of course, for logical purposes, the people who administer it are not part of these representatives. The governing structure is made up of the parties. And these parties agree on what this bargaining council will do. This is why, for instance, if a person is dismissed, because there's a procedure agreed upon, this person is dismissed, and if he goes to a bargaining council, the bargaining council will arbitrate and make a ruling on whether, for instance, the dismissal has been fair or unfair. But that ruling is binding on the parties.
Can you outline who is currently represented in the PSCBC and how this affects their votes when they vote?
Look, I don't necessarily know the current configuration, but I know that, and let's clarify this. As you know, as I said, there's a subset which is education. Now, education has got what they call the Education Labor Relations Council. Now, that's where the dispute resolution takes place. But the actual collective bargaining takes place in the PSCBC. I know that, for instance, a union like PSA is represented there. I know SADTU is there. I know NEHAU is there. I think POPCRU is there. I think like DINOSA is there, and I think a number of other unions. Some of the unions have put together their membership for the purposes of collective bargaining to meet the threshold. Then you then also have the state. Now the state is led generally by the Department of Public Service and Administration, but it would have representatives from the various or some of the line function department, which constitute the state team to the PSCBC.
What are the benefits of taking part in the PSCBC?
Look, a bargaining council, and that's one of the critical objects of the Labour Relations Act, is the creation of labour peace. We shouldn't have a situation where trade unions and employers, generally, whether in the public or in the private sector, just start by fighting. There must be a place where we meet, identify common interest, resolve disputes. So for the sake of labor peace, and across the world, by the way, this is the system which is used to make sure that you build harmonious relations.
You mentioned that the government can just implement its offer unilaterally after a deadlock. So what are the other recourses for workers after the employers implemented the offer unilaterally?
And let's start it here. There is a deadlock, and the parties have now gone for conciliation to the bargaining council. There is still a deadlock, and that is confirmed by a certificate of non-resolution. Now, if a union were to take any industrial action, which could be a strike or a go-slow or a picket, that is the first requirement, that there is confirmation of a dispute. So the first step is to have that certificate. But let me indicate, and one has checked the constitutions of the various unions. Now the law requires that before you go on strike, if the industrial action that you want to take, you must ballot members. So it's not automatic that you can just call a strike. One of the requirements, the first one is that there's a certificate of non-resolution. The second one is that there must be a ballot of the members. So the members themselves must say, we want to go on strike. Although that is the law, but if you look at the policy of the constitutions of many unions, they are mandate driven. So it is the members, not the leadership, who ultimately take a decision. So what that means is that if the leadership, for argument's sake, were to feel that the best option is a strike, and the members say we don't want to go on strike, so there can't be a strike. If the members say we want to go on strike, and the leadership says you can't go on strike, then of course there's a problem. And I think the members will have to obtain, because that is what constitutes the body of the rights of the members. So let's assume the decision is to go on strike. We now have a certificate of non-resolution. We have balloted members. The majority of members say we're going on strike. Now the next step is we need to settle the picketing rules, because no strike happens without you settling the picketing rules or having the picketing rules in place. Then let's say we have the picketing rules. We're now ready to go. We are now required to give notice, 48-hour notice of a strike. So then we're ready to go. Then we can then withdraw labor. But the matter doesn't end there, because the recourse now of the employees is a strike. The employer has got another recourse. The recourse is to lock them out. Locking them out means it declares them as not being at work. And that comes with the consequences. One of the consequences, of course, is what is generally referred to as the no work, no pay principle, where the employer says, because you are not at work, I'm not paying you for the days that you are not at work. Now, there is, of course, in law, a procedure that must be followed. So the employer cannot simply say, because you are not at work, then you are punished with a deduction from your salary. The law is very specific that to deduct from an employee's salary, you need one of three things. You either need an agreement. That means that probably at the end of the strike, and if there's a decision of the employer to implement the no work, no pay principle, it can consult with the unions and agree that, look, do a deduction. And often what happens is that there will be an agreement on how many days, and you know, how many days do you deduct in 1 month, you know. But that is also because there's a limit of 25% to what you can deduct from an employee's salary in any given stage. So that is the first option, is to have an agreement. The second one is that when you have an arbitration award. So if the employer intends to deduct for no work, no pay, it may have to go to the bargaining council, declare a dispute, and get an award that says you are authorized to deduct, and because there has to be certainty about how many days are involved in process of deduction. Or you can actually get a court order that says you can deduct from those people who were involved in a strike. Quite often, employers simply say, because SADTU was on strike, all members are deemed to have been on strike. That's actually not the correct legal position. You still have to verify in respect of each employee, because the fact that, let's say, as I said, people is balloting, the majority will say, we want a strike. There could be 10% that says, we don't want to go on strike, and they want to go to work. You can't, in law, prevent them from going to work because they are members of a union which resolved to go on strike. They still have a right not to go on strike. And if they render services during the strike, they cannot be visited with no work, no pay.
Our experience as a union for the past 2 years, there were certain sectors among some of the members saying, we should go on strike, whereas others were just quiet. So what are the challenges which come up with going to a strike after the deadlock?
Well, firstly, as I say, remember a trade union, it's an autonomous body in terms of its constitution, and it can only do what its constitution authorizes it to do. Now, just for practical purposes, let me use the example in the PSCPC. There are quite a number of unions there. They don't, and it's not, there's nothing unique about it. There's nothing unusual or weird about it, that they may not share the tactics of how they put pressure. Some people may feel that a strike is the best thing. Some people may not feel that way. But the bottom line in the whole thing is that whatever position you take, it must be a mandated position. Hence, I said earlier that even if the leadership strongly feel that there must be a strike, we must go on strike, for instance, it is the members, based on a balloting process, who must take that decision, not the leadership, you know. So when leaders would say, we think the best thing is to go on strike, regard that as a proposition to members. But the actual decision is a decision that must arise from a ballot, you know. So it is not unusual, and this happens across the world, that trade unions, even in the same sector, facing the same set of circumstances, may find themselves in different positions with regard to which action to take, you know. So I don't think anything turns on the fact that there are those who may believe that there must be a strike and those that don't believe that there must be a strike. For me, and in law, the question is whether the members have voted in the majority for a strike. And that would be the members of the individual union. So each union that takes its members on strike has got the obligation to ballot.
Let's say the union has received a certificate to go on strike. Is there a time frame where the certificate should be used?
The certificate remains valid because it relates to a dispute that remains unresolved.
So it means you can get the certificate
And 6 months
in January,
later,
then strike on around May.
Certainly.
We've seen a situation where some of the unions received a certificate. And among our members, there was this excitement to say, you've sold out, other unions they are going on strike. This is what you should be doing. But later, the unions didn't go on strike. They were just saying, well, we are going to strike, we are going to strike. They engaged on pickets. What is the difference between strike and picket?
Okay, let's put it this way, and I think I would be careful to suggest that those who spoke about a strike were sort of bluffing necessarily. Part of the dynamics in a labor environment is that there's also the issue of psychological warfare, but there's also an obligation on the part of the leadership to provide direction. So when, for instance, the leadership would announce that they prefer to go on strike, and I think sometimes we must be careful because we may miss the actual terminology which is being used. I think my understanding and my own analysis was that in the greater part of the instances where strike was spoken about, the leadership did feel that the way to go is a strike. But as I said, the final decision is taken by the members. I wouldn't think you are a weak leader if you were to propose that there be a strike and the members say there shouldn't be a strike. It doesn't make you a weak leader. You're actually a good leader that listens to the mandate of the members. Remember, there's also an issue of legal liability, that when you embark on a strike in contravention of the law, you may, as a trade union, you may be held responsible and liable. So, as I say, for me, the agitation towards a strike, I regard it as part of the discourse towards how you respond to a collapsed collective bargaining process. Now, a picket is a protest where people would say, okay, we do go to work. At lunchtime, we demonstrate, we protest to highlight our cause. It may as well be that it happens as part of a strike, because remember, the strike is the withdrawal of labor. So you're not going to work at all. You're not rendering any services. But what usually happens, and I think this is a morale boosting thing, is that when workers go on strike, they congregate and then they picket, and that is why the picketing rules become important. So a strike does not necessarily include picketing, but a picketing can happen during a strike.
Considering the current situation, is there any appetite among workers to go on strike if they don't get what they want?
I think it's an option which remains available because it's part of the dispute resolution mechanisms. But I also, and this is my personal view, that I think we must also be careful not to push people beyond the limit, because, as I said, historically we have a challenge of an agreement that was signed and ultimately set aside in court after 2 years of its implementation. I'm sure it has left people a bit quite irritated. We have had the unilateral implementation in the past year, and it aggravates the situation. And as I said, it may undermine the mutual trust and good faith that must exist in a collective bargaining process. So the question of whether there's appetite or no appetite will be probably, amongst others, be influenced by the extent to which workers are pushed and to the extent that they feel that they are now having their backs against the wall. So I wouldn't necessarily think if workers do not react in the manner that we would ordinarily expect, that they would simply say, let's go on strike, it means that they are cowards or they are weak or they don't have an appetite. But I think in all fairness, my own sense is that people have been quite reasonable. I am not sure the extent to which they'll continue to be reasonable relative to the environment which is evolving.
The difference between protected and unprotected, what does that mean?
The Labor Relations Act sets out the requirement for what we call a lawful strike, and that's probably what we call a protected strike. Now, that is a strike where all the procedures that I've explained have been complied with. Where there was a dispute, where there's a certificate of non-resolution, where they are picketing rules, where there's balloting of the members, where there's proper notice to the employer. The idea of protected simply means you cannot be dismissed for being on strike. Remember, when you are not on strike, you are not at work. If there is no strike, for argument's sake, and you were not go to work, you would be committing misconduct by absenting yourself from work. But because there's this procedure that has been followed, your absence related to that action is protected in law. So you can't be disciplined solely for the fact that you didn't go to work because of a strike. That is what what you generally refer to as a protected strike. Then we have got what you refer to as an unprotected strike. An unprotected strike is where no procedure is followed. And people just decide, no, as a group, we are not going to work, we are going to protest and all these kind of things. So you are committing misconduct because you are acting in contravention of the law. So the employer has the right to discipline you for that conduct, you know. Now, and that's what brings up the major distinctions. Now, in a protected strike, the employer can't go and get an interdict to prevent you from embarking on the action. But where there's an unprotected strike, the employer can go to court and actually get a court order to interdict you because you are actually acting in contravention of the law. And there are a host of consequences. For instance, as I said, you will be committing misconduct. You stand a risk of being charged and found guilty and probably dismissed for that. You would not have the protections that you would have if the strike was lawful and as you call it, protected.
Mannya, another part is indefinite strike. What do they mean when they say the strike is indefinite or will engage on indefinite strike?
There's probably nothing called an indefinite strike. I think what the probably proper terminology would be, people are on a strike indefinitely. Remember, when you strike, the law doesn't say you must only strike for 10 days. You are striking as long as you deem it necessary. You are the one starting the strike, so you are the one who will decide when you want to end the strike, unless there's a court order that says the strike must end, because in certain instances there could be a court order that says you must end the strike. So there's no limit to how long you can go on strike. You decide, you start in the strike on the 2nd, you will stop it on the 5th, or you will stop it when you are really tired, or you will stop. But remember, as I said, it goes with the consequences. The longer you are on strike, the longer you are at the risk of not earning anything at some point, because you will be owing the employer a whole number of days, which if the employer decides to implement no work, no pay, you will find yourself having to repay all those days that you were on strike. Let me just indicate, maybe by way of example, some years back, there was a union called the South African Railways and Harbours Union, SADTU. And SADTU was organizing in the railway industry. And there was a strike, and I think probably that's what you could refer to as an indefinite strike, because that strike in real terms never ended. When it ended, I think it was when probably the majority, if not all the workers that participated, were dismissed. So many people had died because the strike was also very violent. You know, and you don't even know whether the violence came from within SADTU itself, or it was, you know, the apartheid agents were burning people's houses to discredit that. So part of a value judgment that you make about how long you embark on a strike is the emotional impact on the members, because the longer probably it takes without them getting what they want, the more agitated and irritated they become, and the risk of either people abandoning the strike and going back to work, or the strike turning ugly and violent stance. So when you talk about an indefinite strike, you actually looking at such risks, inclusive of what will happen to those who may ultimately face no work, no pay, and all those kind of things.
Greetings, comrades. With the advent of social media, SADTU has evolved with the times to bring you the educator's voice on your social media platforms, to report on issues regarding your conditions of service, union programs, and to highlight the successes of members who excel in the profession, and many more. This is SADTU Online TV, coming live from Matthew Goniwe House. This is Nomusa Cembi, your host. Amandla.